everyone, today I want to talk to you about the 10 things you should know about SEC investigations. I know you never want to be the subject of one, but you should know these 10 things in case you are, or in case you're ever called in as a witness to one. Now, the first thing you should know, and I know this is a question you're asking, is why? Why am I part of this SEC investigation? There could be a number of reasons why. You could be a witness, you could be a party that has books and records related to the person or issue under investigation, or you could be the person under investigation. Either way, there are some common reasons why an SEC investigation is started. Some common reasons are misrepresentations, theft of client funds, fraud, market manipulation, and more. So if you are worried that this is something that is happening in your firm or something that you know in the deep, darkest parts of your soul that you've committed, then yeah, you can bet your bottom dollar that you are the subject of the investigation. But you could also be the owner of a firm where someone else, a previous advisor, is currently under investigation, and you have the documents and information related to the issue at hand. Even in this scenario, your firm could be found liable for certain failures in supervision. So you want to make sure if you are part of an SEC investigation, whether you're a witness or the party of the investigation, you need to act swiftly and decisively in responding. The second thing you should know is that there are two types of investigations, an informal investigation and a formal investigation. In an informal investigation, you will receive a request for information and documents. This is the SEC initiating a fact-finding mission to find out if there are legitimate violations of securities law. Most SEC investigations start as informal investigations. Following an informal investigation, the SEC can take one of three courses of action. They can decide that there's been no wrongdoing. They can issue a warning letter that initially states, we found some wrongdoing, but nothing to escalate this further. Or they may then take the facts and information they received during the informal investigation and turn it into a formal enforcement investigation. The third thing you should know is that a formal investigation is incredibly serious and should be treated as such. In a formal investigation, the SEC has established facts, information, and documentation that show securities violations. And during the course of a formal investigation, the SEC has subpoena power, where they can subpoena other third parties for information and documentation. Even parties that may not necessarily want to help the SEC and are an advocate for you, under this subpoena power, they can be forced to testify. The fourth thing you should know is that neither an informal or formal investigation is disclosable on your Form U-4. It only becomes a disclosable event once formal charges are brought against you, which means it's incredibly important to work with an attorney to make sure they are able to help you get rid of the investigation and resolve it before it's escalated. The fifth thing you should know is that once you are formally charged, it's public. The SEC doesn't give a hot damn about you. What they want to do is protect investors, which means there will be an SEC press release on their website, on their Twitter account, on their LinkedIn account about you. It's going to outline the charges against you, the conduct that led to those charges, and what they are pursuing in terms of remedies against you. That press release is going to be picked up by news organizations within our industry and outside of our industry. You can't hide anymore. So make sure you are doing what you can to resolve an SEC exam before it goes public. The sixth thing you should know is that before things go public, the SEC may give you an opportunity to settle with them. They will send you notice of their intent to file formal enforcement action. This letter they send you is called a Wells Notice. The Wells Notice outlines the charges and the remedies they are seeking against you. It's an opportunity for you to respond and provide information and documentation in your defense. It is not unusual for a well-prepared Wells response to make the SEC reconsider charges and whether to move forward with an enforcement action at all. This is a critical step in the process. If there is wrongdoing found and you legitimately effed up, it's okay. This is also your opportunity to defend yourself and give a reason why the SEC should look at mitigating factors and reconsider the remedies they're seeking against you. Either way, the Wells Notice is an important step in the process and an opportunity for you to settle. So take advantage of it. So the seventh thing you should know, and I know some of you are thinking about this. What if I don't respond? I'm near retirement age and thinking about getting out, or hell, I hate financial services. I'm totally over it. Well, if you don't respond to either an informal or formal investigation, to your Wells Notice, or any step in the investigative process, you are looking for some serious repercussions. What are those repercussions? You are going to be facing a fine, probably a bar from the industry. And if you should ever decide 5, 10, 20 years down the road that you'd like to give financial services another chance, once you're barred, there's no way to get back in, especially when the bar is because you never responded to a FINRA investigation. And if you say, hey, screw it, it's FINRA, no one likes FINRA anyway, I'm going to go join an RIA, that FINRA bar will also affect your ability to be affiliated with an RIA or become licensed as an investment advisor representative. So unless you are 150% sure that you are ready to get out of the industry and you never want to walk back through those financial services doors, you should respond. The eighth thing you should know is that if you ultimately decide to settle with the SEC, you are allowed and can request a payment plan. Yes, who the hell has $200,000 in their back pocket? If you do, let me know if you're single. I've got a single sister. But if you don't, you can ask for a payment plan. The SEC at the end of the day wants to see that the fine is paid in full, but they're willing to work with you and your firm to create some sort of payment plan in order to pay off the fine. So take advantage of open communications with the attorneys at the SEC and work out a deal that you can live with. No one wants to have to pay a hefty fine, but I'd rather pay it in small lumps than mortgage my house, sell my home, get rid of my car, all of those things to pay one lump sum. So remember, talk to the regulators. You can work out a deal that you can live with. The ninth thing you should know about SEC investigations is that they can end up in a hearing before an administrative judge. The SEC can file a civil action in civil court, or they can actually also bring criminal proceedings against you. So it's really, really, really important that you go forward with the 10th thing I'm telling you, which is hire an attorney. I can't tell you how many advisors, brokers come to me well into the investigative process after they've turned over information, after they've turned over documentation, after they're on the record admitting to wrongdoing, and then asking me and my team for help to get them out of it. If you want to avoid the disclosure, if you want to avoid the fine, if you want to avoid the bar, if you want to avoid going before an administrative judge, if you want to avoid the press releases, the fines, the potential criminal proceedings, then as soon as you find out that there is an investigation and you are part of it, call an attorney. The cost of not hiring one is going to outweigh the cost of having an attorney defend you. So pick up the phone today, call 770-462-2118, and talk to a member of our legal team. We're here to defend you, and fuck the regulators.